Meeting of the 21st session. At this meeting, the Assembly will hear the progress report by the coordinators and then turn to the introduction of draft resolutions. Let me now turn to the progress report by the coordinator. I would first like to turn to the working group on the program budget for 2023. And I'd like to give the floor to the coordinator of the working group, Ambassador Frances Lanitou. You have the floor, Ambassador.
Thank you very much, Madam President, distinguished colleagues. Thank you for the opportunity to provide an update on the discussions on the proposed programme budget for the Court for 2023. We have made good progress, but we have not yet reached agreement on the figures, and there are some elements still to be agreed in the draft resolution. I have therefore convened informal consultations which will begin immediately after the conclusion of this plenary meeting. I intend to make a proposal, and it is my sincere hope that it will be the landing point on which states parties can reach consensus. I have also convened a meeting of the working group on programme budget for this afternoon at 3 p.m, where I hope we will be able to agree the draft resolution and the draft report of the working group. I'm very grateful to all involved for the constructive and flexible attitude with which they have approached our negotiations. Thank you, Madam President.
Thank you, Madam Ambassador, and really appreciative of your efforts to reach consensus on the budget. Obviously, very difficult task, and also thanking all the delegations on their constructive approach to this challenging topic. Now I will turn to the introduction of the draft resolutions. First, I'd like to give the floor to the coordinator of the omnibus resolution, Ms. Virpi Laukkanen, to introduce the draft resolution contained in document ICC ASP21/L3. Ambassador, you have the floor.
Madam Vice President, distinguished delegates, thank you for giving me the floor. I have the honor to introduce the draft resolution on strengthening the International Criminal Court and the Assembly of States Parties, also known as the Omnibus Resolution, which is contained in document ICC ASP/21/L3, dated 8th December 2022. The document has been distributed via email. For the preparation of the draft resolution, 8 rounds of consultations were held, 7 in New York and 1 in the margins of the current Assembly on Wednesday, 7th December. The draft resolution reflects the outcome of these informal consultations. There are 22 sections to the resolution and 4 annexes, dealing with ways to strengthen the International Criminal Court and the Assembly of States Parties. The document also contains a placeholder for the outcome of the cooperation plenary, reflected in the 20th operative paragraph of the draft resolution. On the basis of informal consultations, I am satisfied that there is wide support for this resolution. I therefore submit the resolution for the consideration of the Assembly, and it is my hope that the resolution can be adopted by consensus. I would like to thank all delegations for their active and constructive contributions. I would also like to extend my thanks to the colleagues at the Secretariat for their invaluable support. Thank you, Madam Vice President.
Thank you very much for introducing the draft omnibus resolution. I now invite the state party representatives On the review mechanism, Ambassador Poor van den Ijssel to introduce the draft resolution on the review of the International Criminal Court and the Rome Statute system contained in document ICC ASP 21/L6. You have the floor, Ambassador.
Thank you, Madam President. I have the honor on behalf of the review mechanism to introduce the draft resolution titled Review of the International Criminal Court and the Rome Statute System, contained in document ICC/ASP/21L.6. The draft resolution contains 9 preambular paragraphs and 14 operative paragraphs, and it reflects, to a large extent, agreed language from previous resolutions on the review process. By the resolution, the Assembly would inter alia extend to the 22nd session the mandate of the review mechanism, and it would also invite the Court through the registry, in close consultation with the Bureau, to develop a detailed proposal for a 10-year policy, addressing also its financial applications for approval at the 22nd session. Madam President, we held 2 rounds of consultations, and we are very happy that we could find agreement on the text. We would like to thank all delegations who participated in the consultations for showing flexibility, which allowed us to agree on the draft of the resolution text. The support for the resolution is indicative of the support for the review mechanism and the review process as a whole, which we heard in the plenary on the review of the court and the Rome Statute system last Wednesday. I submit to the Assembly the draft resolution on the review of the court and the Rome Statute system contained in document ICC ASP 21L6 and hope it can be adopted by consensus. I thank you, Madam President.
Thank you very much, Ambassador, and obviously we do all hope that it will be adopted by consensus. I now give the floor to Ambassador Jose Antonio Zabalgoitia on behalf of Juan Manuel Gomez Robledo, Chair of the Working Group on Amendments, to introduce the draft resolution on amendments to the Rules of Procedure and Evidence contained in document ICC ASP/21/L7. You have the floor, Ambassador.
Muchísimas gracias, señora vicepresidenta, por darme la palabra. Buenos días, señores distinguidos delegados. Tengo el honor de presentar el proyecto de resolución titulado Enmienda a las reglas de procedimiento y prueba de la Corte Penal Internacional, contenido en el documento que ha señalado la vicepresidenta, el de 8 de diciembre de 2022. Lo hago en nombre y en representación del presidente del grupo de enmiendas, el embajador y mi amigo Juan Manuel Gómez Robledo. El proyecto de resolución refleja el resultado de las discusiones que tuvieron lugar este año en el grupo de estudio sobre gobernanza y el grupo de trabajo sobre enmiendas, y la resolución fue aprobada por el grupo de trabajo a través del procedimiento de silencio el 1 de diciembre de 2022. Basándome en el resultado de las consultas informales sostenidas, estoy contento de informar a la Asamblea que existe consenso para apoyar esta resolución. Por lo tanto, someto la misma para la consideración de la Asamblea. Quisiera agradecer a todas las delegaciones su activa y constructiva contribución y al grupo de estudios sobre gobernanza por su fructífera colaboración. Esperamos que la resolución pueda ser aprobada por consenso en esta Asamblea. Muchas gracias, señora vicepresidenta.
Thank you very much, Ambassador, for introducing the resolution. I would like to now invite the co-facilitators for cooperation to introduce the draft resolution on cooperation contained in document ICC ASP/21/L5. I give the floor to the representative of France to introduce the resolution. You have the floor.
Merci Madame la Présidente. J'ai l'honneur de présenter au nom des ambassadeurs de la République du Sénégal, Momar Gueye, et de la République française, François Alabrune, le projet de résolution sur la coopération qui porte la cote ICC ASP 21L.5. En signant Puis, en ratifiant le statut de Rome, en particulier son chapitre 9, nous nous sommes engagés à apporter notre aide à la Cour afin qu'elle puisse remplir pleinement ses missions de lutte contre l'impunité pour les crimes les plus graves. Ce projet de résolution rappelle l'importance d'une coopération globale et efficace de la part des États parties, des autres États, des organisations internationales et régionales et de la société civile. Dans ce projet de résolution a été réaffirmée l'importance de thématiques telles que l'exécution des mandats d'arrêt, l'intégration du statut de Rome dans les législations nationales en matière d'enquête financière et de gel des avoirs, et ainsi que les accords de coopération volontaire. Les facilitateurs sur la coopération ont aussi proposé aux États parties, dans le cadre de la procédure de silence lancée hier soir, d'intégrer au projet de résolution un paragraphe supplémentaire relatif à la séance plénière sur la coopération tenue hier, le 8 décembre, partie dont je vous fais la lecture. Se félicite de la séance plénière sur la coopération qui s'est tenue au cours de la 21e session de l'Assemblée et qui a été l'occasion d'un dialogue renforcé entre les États parties, la Cour et les membres de la société civile sur la coopération volontaire, ainsi qu'une discussion plus technique sur la question de la protection des témoins. Et se félicite de la signature d'un accord de coopération sur l'exécution des peines, conclu entre l'Espagne et la Cour lors de la séance plénière sur la coopération. Je soumets donc le projet de résolution qui vous est présenté ce jour et qui a fait l'objet d'un accord par consensus au sein du groupe de l'AE à l'examen de l'Assemblée et recommande qu'il soit adopté par consensus. Je voudrais également remercier le secrétariat de l'AEP pour sa contribution précieuse aux côtés de la France et du Sénégal pour l'organisation de la session plénière. Je vous remercie, Madame la Présidente, et j'ajoute une demande que je vous soumets de savoir s'il est possible d'exceptionnellement donner la parole à la liste d'États et d'ONG qui n'avaient pas pu prendre la parole hier pendant la plénière coopération, compte tenu des contraintes de temps. Merci beaucoup.
Thank you very much for introducing the draft resolution on cooperation. I understand that the facilitators would like to request that the Assembly reopen the 7th plenary meeting on cooperation in order to conclude the speakers list, meaning allowing those speakers who requested to be included on the speakers list by the deadline of 6 December. This will be on the understanding that we are opening a plenary on an exceptional basis. If there is no objection, does the Assembly agree to proceed accordingly? I see none. Thank you very much. And now I give the floor to the speakers according to the speakers list from the yesterday's plenary. First, I give the floor to the Czech Republic.
Thank you, Madam President. The government of the Czech Republic is very proud that it successfully finished negotiation on the cooperation agreement on the protection of witnesses. The agreement was signed just last Friday, and after its entry into force, it will allow us to contribute to the fight against impunity by a very practical means, providing protection of witnesses who are a necessary component of each technical criminal proceeding. Since we are supposed to be focusing on technical aspects, let me to share with you two remarks related to the process of negotiation itself. First, we value very much the extraordinary cooperation with the registry, in particular with the witnesses and victims section. Their insight and ability to shed light on issues of practical cooperation with the court has been indeed essential. Second, the negotiation process would not have been successful without intensive consultation with relevant government bodies that share the responsibility for future implementation of the agreement. We consider necessary to have all the implementation bodies on board since the very beginning of the process itself. I thank you, Madam President.
I thank you. And now I give the floor to Belgium. You have the floor.
Merci Madame la Présidente. Je vais, avec votre permission, céder la parole à mon collègue Monsieur Jonas Périlleux du ministère de la Justice et de l'Autorité centrale de coopération dont j'ai parlé hier dans la première partie du segment. Merci.
Bonjour à tous. Merci de nous accorder une nouvelle fois la parole pour poursuivre les échanges fructueux entamés hier lors de la session plénière sur la coopération. Je souhaite tout d'abord remercier l'ensemble des intervenants pour leurs présentations très instructives qui ont souligné les défis auxquels la Cour est confrontée en matière de coopération dans le domaine de la protection des témoins. Les dépositions faites par les témoins constituent des pièces centrales dans les dossiers portés par le bureau du procureur devant la Cour. Or, sans protection adéquate des témoins, ceux-ci ne seront pas enclins à livrer leur témoignage. La Cour, ne disposant pas de ses propres forces de police et n'ayant pas vocation à assurer la protection des témoins menacés sur le long terme, il appartient aux États d'assumer équitablement la charge de la protection de ces témoins. Comme cela a été rappelé lors de notre intervention hier matin, la Belgique dispose depuis 2004 d'une loi spécifique relative au traitement des demandes de coopération. Cette loi contient une disposition particulière relative à la protection des témoins à la demande de la Cour. Elle est complétée par un accord bilatéral conclu avec la Cour relatif à la protection de ces témoins en Belgique. Cet accord prédéfinit les modalités pratiques de protection tout en permettant de les adapter au cas par cas. Nous souhaitons encourager les États parties qui ne l'ont pas encore fait à prendre les dispositions adéquates pour être en mesure de donner suite à une demande de protection de témoins qui émanerait de la Cour. Merci de votre attention.
Thank you very much. Now I give the floor to Serbia. You have the floor.
Thank you, Madam Vice President, and many thanks for allowing us to come back to this issue today. I would also like to thank all the states parties for the flexibility as well as the co-facilitators for allowing us and making sure that we can speak today as well for their work throughout the year. On the voluntary cooperation agreements in relation to relocation of witnesses and witness protection, the Republic of Serbia has listened yesterday very carefully, the panelists as well as the registrar, and we would like to thank the registry for all the efforts in finding appropriate solutions for this very important issue. We very much welcome the fact that 13 witnesses have been that the solution, long-lasting solution, has been found for 13 witnesses, but we flag out that 21 has still been, for the 21, the solution has still not been found. We are also concerned with the fact that there is still an important deadlock in this field. Knowing from our own experience how important this issue is for achieving the justice and accountability, we would like to echo the plea of the registry to the states parties to support this matter, including through temporary relocation, until the long-lasting solution is found. Safety of witnesses and protection of their families is of utmost importance. We cannot expect justice to perform at its best when witnesses live in fear, not only for their own lives, but also for their dear ones. I would like to conclude, Madam Chair, by thanking again the facilitators for their hard work, as well as the registry and specifically the registrar for his warm and sincere approach and flexibility and understanding in all situations. It is of crucial importance for the SPs to know that they have a counterpart like that. Thank you so much.
Thank you very much. Now I turn to observer states. I give the floor to the United States.
Madam Vice President, distinguished colleagues and guests, I want to thank the co-facilitators for inviting me to take the floor alongside friends, NGO delegations, the ICC, and committed delegates here to participate in this important discussion on witness protection and cooperation with the court. The importance of state cooperation in general and witness protection in particular is axiomatic, so I won't belabor the point here in the interest of time. I have made the protection of witnesses one of my priorities as Ambassador at Large for Global Criminal Justice, and we have been actively engaged with the registry, other states, and civil society to identify areas where the United States may be able to help by finding gaps, discussing potential solutions, and looking for ways to partner. In particular, we are keenly aware of the challenges that the ICC and other international justice mechanisms face when it becomes necessary, as a matter of last resort, to relocate witnesses, whether they are victims or insiders. In recognition of these challenges, my office is participating in a global conversation about the imperative of witness protection and witness relocation, the importance of which is now only growing as there are enhanced threats in both national and international prosecutions, and we're seeing a rise in transnational repression. In this context, solutions may require contributions and cooperation from a number of different stakeholders, including states that may be willing to accept witnesses, including some that may be difficult to place, so long as they have the resources needed to ensure their successful resettlement. States that might be able to provide those resources, even if they are not in a position to relocate particular witnesses themselves, and then civil society organizations that can help ensure that any relocation is successful from the perspective of the witness, him or herself, but also their family members that may be joining a society that is very different from their own. On Tuesday, for example, we joined with the delegations of Argentina, Sweden, and the ICC Registry to co-host a side event that brought together experts and professionals from domestic and international systems to exchange ideas and best practices on these issues. The conversation provided an important and practical forum to discuss these issues in concrete terms and highlighted opportunities to find synergies between states and international justice mechanisms. For example, Dr. Anna Oberland, deputy prosecutor from Argentina, shared 9 lessons about witness protection drawn from Argentina's long experience prosecuting cases involving gross human rights violations during the dictatorship. For example, she noted that each witness is unique and requires a tailored approach to assistance and protection. Personnel who will be working with witnesses need appropriate and specialized training, often across disciplines, to address trauma and other resettlement challenges. And assistance and protection may be needed throughout the duration of a justice process and potentially well beyond, depending upon the nature of the threats. Carl Magnus Nesser, Sweden's Director General for Legal Affairs, shared Sweden's experience resettling ICC witnesses under a voluntary cooperation agreement with the court, including the difficulty at times of working with insider witnesses who may implicate the exclusion clause within the Refugee Convention or other national security carve-outs in domestic law. Ken Fetcher, who's the Deputy Chief of the U.S. Marshal Services, described international training and capacity building work that the United States does with foreign law enforcement authorities and some of the common challenges that witness personnel face around the world, including the rise of biometrics and the impact of social media, which can make it easy to trace witnesses that have assumed new identities. We are interested in exploring whether there could be synergies between this work that we do domestically with ongoing international justice efforts. We also heard compelling appeals from both the ICC Registry and the International Mechanism for Myanmar on the need to facilitate the creation of identity and travel documents, the importance of moving quickly when risks materialize, and the costs associated with lengthy delays in relocation processes. As the ambassador of Argentina observed in his closing remarks, these challenges, of course, are not insurmountable if stakeholders can work together to exchange knowledge, experience, and good practices, which ultimately can improve not only the capacity of the ICC to do witness protection, but also within national systems. We acknowledge that the court has already received substantial cooperation and contributions from many states in this room. And indeed, I would like to take this opportunity to congratulate the Registry and the Czech Republic on the important agreement signed last Friday regarding witness relocation. And in this regard, and in closing, I will echo the remarks made by the ambassador to the Czech Republic when signing that agreement on behalf of her state. Without witnesses, there will be no trials, no justice for the victims. As I stated during my intervention during the general debate earlier this week, the United States is actively looking to enhance our practical cooperation with this court and to put our relationship on a more durable path. The seriousness of this effort, I hope, is underscored by the extent to which senior U.S. engagement has happened with the court, including the bipartisan delegation of U.S. senators who visited last month. As we continue to enhance U.S. cooperation, we look forward to the opportunity to continue to exchange views with states parties on practical elements of cooperation and practices that have been instrumental in enhancing the court's efforts. I look forward to continuing this conversation during the Quito high-level seminar that Ecuador announced it will be hosting with the ICC for the Americas in June. Thank you again for inviting the United States to participate in this timely conversation. Most important, I thank all of you here for your contributions to international justice, peace, and security.
Thank you for your statement, Ambassador. And now I turn to the civil society segment. I give the floor to Al-Haq.
President, it is my pleasure to deliver this statement on behalf of Al-Haq, Human Rights Watch, Al-Mizan Center for Human Rights, the International Federation for Human Rights, the Palestinian Center for Human Rights, and the Women's Initiative for Gender Justice. Excellencies, the ICC relies on state cooperation and civil society as essential actors in delivering on its mandate to hold perpetrators of the most serious crimes accountable for their crimes. When the ICC and international justice more generally was at risk due to the threats aimed at deterring cooperation with the court, civil society firmly stood up for the court. Protecting civic space is thus crucial for ensuring that the system works for the benefit of the victims. We welcome the adoption by the Bureau of the Assembly a strategy and annex of a compilation of good practices to counter any threats against the court, its officials, and those cooperating with it. Now that this strategy and annex have been adopted, it should be put in effect when threats or attacks, including against civil society and human rights defenders, are identified. We are seeing at this very moment attacks against those cooperating with the court. This includes an attack on Palestinian civil society organizations. The Israeli government has outlawed 6 prominent Palestinian civil society organizations, several of which have been submitting information to the ICC about the alleged crimes committed by Israeli forces. The Israeli forces have also raided the offices of these organizations. These actions have been internationally widely condemned. Al-Haq and nearly 200 organizations have sent a letter to the president of the ASP, urging her to implement this new strategy, including by coordinating sending a letter to the Israeli authorities condemning their attack on Palestinian civil society and demanding their unlawful designations to be rescinded. Publicly condemn Israel's designations and their threat against civil society, and defend human rights defenders and civil society organizations cooperating with the court, and inform the ASP Bureau and the ICC parties of the threat and sanctions against Palestinian civil society, and encourage them to express their support and their condemnation of Israel's designations. We also call on individual state parties to develop their own strategies to counter attacks against civil society and human rights defenders. We hope you all can firmly and unequivocally stand with the human rights defenders around the world. Thank you.
Thank you, and I give the floor to the Moroccan Center for Peace and Law. You have the floor.
Je vais parler en arabe. شكرا سيدة الرئيسة. اسمي هشام شرقاوي، رئيس المركز المغربي للسلام والقانون والمنسق الإقليمي للشبكة الإفريقية حول العدالة في شمال إفريقيا، ونشتغل حول موضوع التعاون وحماية الشهود. يترتب على عدم التعاون مع المحكمة عدم تطبيق القانون على المتورطين في الانتهاكات الجسيمة وإفلاتهم من العقاب، مما ينتج عنه غيابة الردع وتحقيق العدالة، وهذا يؤثر على فعالية المحكمة. هذه الوضعية قد أثرت على منطقتنا العربية في الشرق الأوسط وشمال إفريقيا، حيث مرت 24 سنة من تأسيس المحكمة، وما زالت هذه الدول تتعرض لأبشع الانتهاكات الجسيمة لحقوق الإنسان في فلسطين، في اليمن، سوريا والعراق، وهذا مرفوض أخلاقيا وإنسانيا وقانونيا في ظل الصمت وعدم تعاون المنتظم الدولي مع المحكمة. فهذه الشعوب تستحق العدالة والكرامة والتحرر من التسلط والتحكم في مصيرها. سيدة الرئيسة، إننا نؤمن كمدافعين على حقوق الإنسان بقدرة المحكمة على تحقيق العدالة في الجرائم الدولية إذا حافظت على استقلاليتها وتوفرت لها الإمكانيات المادية والدعم السياسي. وفي الختام نطالب جميع الدول وعلى رأسها دول الشرق الأوسط وشمال إفريقيا بإلغاء جميع الاتفاقيات الثنائية التي تعرقل التعاون، وفتح صفحة جديدة مع المحكمة الجنائية الدولية والتعاون مع أجهزتها في ظل المتغيرات الجديدة والتحديات الجديدة. شكراً.
At this moment, I just recall that the list of speakers from yesterday is exhausted, and we'll turn to the next agenda item. Now we will begin to consideration of the agenda item 14, recommendations concerning the elections of registrar. The draft recommendation which the Assembly will make pursuant to Article 43, Paragraph 4 and Rule 12, Paragraph 3 of the Rules of Procedure and Evidence is contained in document ICC ASP21 L9, which is before you. I recall that the Bureau had previously entrusted the Hague Working Group with the preparation of the draft recommendation on the election of registrar. I will introduce the draft recommendation in my capacity as coordinator of the Hague Working Group. It is my pleasure to introduce the draft recommendation of the Assembly concerning the election of the Registrar of the International Criminal Court, as mentioned, contained in document ICC ASP/21/L9. As you would recall, this is a mandate of the Assembly contained in resolution ICC ASP/20/Res4. Following the public roundtables with the candidates for the post of registrar, the Hague Working Group held a number of meetings, some of them in hybrid form, in order to enable New York-based delegations to participate in these important discussions. Subsequent consultations continued at the Hague Working Group. The delegations made proposals to expand the recommendations previously made by the Assembly in 2017, and all proposals were thoroughly considered and discussed. After a very lively debate, we arrived at a result that I believe is balanced and take into account all the various suggestions and concerns expressed. In the preamble paragraphs, the Assembly would refer to the list of the candidates, which it had received from the Presidency of the Court, in accordance with the Rule 12 of the Rules of Procedure and Evidence. The Assembly also takes into account the due diligence process established for candidates for registrar to assist in the determination of the criterion of high moral character as required by Article 43, Paragraph 3 of the Rome Statute, and the outcome of the work carried out by the independent oversight mechanism. The Assembly also recommends that the judges take into account following elements, which include criteria governing the employment of staff of the court provided in the Rome Statute. That would include, among others, the necessity of securing the highest standard of efficiency, competency, and integrity, assigning high priority to equitable geographical representation, gender balance, and an adequate representation of the principal legal systems of the world, while emphasizing the need for preserving diversity and multilingualism, as well as recognizing rotation as a useful tool. Proven managerial skills and knowledge of the non-judicial aspects of the administration. Commitment to and experience in the promotion of gender equality and a safe, inclusive, equal, and respectful workplace environment. I would like to thank all participants in the discussions for the spirit of flexibility and compromise, which contributed to the successful conclusion of the discussions in the working group. The draft recommendation was agreed by consensus in the Hague Working Group and submitted to the Bureau. I submit to the Assembly the draft recommendation on the election of the registrar contained in document ICC ASP21/L9 and recommend its adoption by the Assembly by consensus. The Assembly will continue its consideration of Agenda Item 14 at an upcoming plenary meeting when it will take action on the draft recommendation contained in document ICC ASP21/L9. Now we will I understand that Mexico would like to take the floor. Ambassador, you have the floor.
Muchas gracias, señora vicepresidenta. La delegación de México es parte del consenso para la aprobación de la resolución con la recomendación de la Asamblea de Estados parte a los jueces para la selección del secretario de la Corte. Quiero, en primer lugar, agradecer su enorme talento diplomático para lograr la resolución, para llegar al texto que hemos acordado. Segundo, quiero señalar también que ese texto refleja el sentimiento de los Estados parte respecto a la persona que debe ocupar el secretariado de la Corte. Y tercero, y muy importante, quiero apelar a los jueces a que tomen en cuenta muy seriamente esa resolución que presenta ahora la Asamblea cuando tomen la muy importante decisión de determinar quién ocupará el secretariado de la Corte. Es todo lo que tenía que señalar. Muchas gracias por darme la palabra.
Thank you very much, Ambassador, for your very complimentary words, and I'm really happy that we were able to arrive at a balanced and satisfactory text of resolution. Thank you for your effort and, in fact, efforts of all of you. We will now revert to consideration of Agenda Item 13, election of 6 members of the Committee on Budget and Finance. The 6 vacancies that will arise on the committee on 31st December 2022 upon the expiration of the terms of office of 6 members of the committee are as follows. African states, 1 seat. Eastern European states, 1 seat. Latin American and Caribbean states, 1 seat. Western European and other states, 3 seats. As regards the Eastern European States Group, the Latin American and Caribbean States Group, and the Western European and other states group, I wish to indicate that since the number of candidates corresponds to the number of vacancies in the regional groups concerned, the Bureau, pursuant to Resolution ICC ASP/1/Resolution 5, recommended that the Assembly elect the following candidates by consensus. Eastern European Group, Mr. Urmat Lee of Estonia. Latin American and other Caribbean Group, Ms. Ana Patricia Villalobos Arrieta of Costa Rica. Western Europe and other states group, Mr. Daniel McDonnell, United Kingdom. Mr. Klaus Stein, Germany. And Mr. Pascal Thomas Hernandez, Spain. As regards to the seat allocated to the African group, the facilitator, Ms. Beatrice Maillet of Canada, following intensive consultations, reported to the Bureau yesterday morning that an agreement had been found. I would like to take this opportunity to thank her for her tireless efforts and thank all the delegation concerned for their flexibility and spirit of cooperation. As a result of the above-mentioned consultations, the Bureau recommends that the Assembly elect by consensus Ms. Yasleen Chaona Chirembo of Malawi and Mr. Sar Lahai Jusu of Sierra Leone on the understanding that the two members would share the seat as follows. Ms. Yasleen Chaona Chirembo will serve for the first half of 3-year term from January 1st, 2023 to June 30th, 2024, and Mr. Sar Lahai Jusu of Sierra Leone will serve for the second half of the 3-year term from July 1st, 2024 to 31st December 2025. Does the Assembly wish to elect the above-mentioned candidates by consensus for the 3-year term commencing on 1st January 2023? I see no objection. It's so decided. I congratulate all the members of the Committee on Budget and Finance on their election. Distinguished delegates, in relation to this agenda item, the Assembly also has before it a draft decision contained in document ICC ASP21/L8, which the Bureau recommends to the Assembly for adoption. I now give the floor to the facilitator, Ms. Beatrice Maillet, to introduce the draft decision. Ms. Maillet, you have the floor.
Thank you so much, Madam Vice President. I want to please very much this morning to introduce, as you mentioned, the draft decision ICC ASP/21 L.8 on the Committee on Budget and Finance. I want to first thank the chairperson of the committee for his report earlier this week, which really showed to all the Assembly the important role of the committee in our activity. The resolution or the draft decision in front of you has been, as you said, recommended by the Bureau, is asking the Bureau, in consultation with state parties, to discuss the allocation of seats of the committee and report back to the 22nd session of the Assembly. I would like to submit this draft decision for consideration to the Assembly, and I hope it can be adopted by consensus. Let me take a moment to thank all state parties for their engagement and spirit of collaboration in these discussions, as well as to thank the Secretariat for their support. Thank you.
I thank you very much for the introduction of the draft decision. The Assembly shall now take action on the draft decision contained in document ICC ASP/21/L8. Is there any delegation that wishes to explain its position before taking action on the draft decision? I see Kenya is requesting the floor. You have the floor.
Thank you, Madam Vice President. Good morning, distinguished delegates. On this issue, before we take a decision on the same, this delegation would want to have an indication on the issue that was the casual vacancy that was raised following the resignation of Ambassador Shava, who was then now moved to be ambassador to the Kingdom of Netherlands. And the Bureau, we had informed, had formed and discussed on how to fill that casual vacancy. I have not heard any word of the same when you were discussing and introducing the resolution. Thank you, Madam Vice President.
Thank you very much. In fact, we will get to the casual vacancy in a second. Anyone else would want to take the floor on the decision proposed? I see none. May I take it that the Assembly wishes to adopt the draft decision ICC ASP/21/L8 without a vote? I see no objection. Draft decision ICC ASP/21/L8 is adopted. I thank you all for cooperation. Is there any delegation that would like to explain its position after the adoption of the decision? I see none. We have thus concluded our consideration of the agenda item 13, election of 6 members of the Committee on Budget and Finance. Distinguished delegates, we shall now address another issue relating to the Committee on Budget and Finance, namely the casual vacancy arising because of the resignation of Ms. Margaret Shava of Kenya, effective 30th November 2022. Ms. Shava had been elected by the Assembly for a 3-year term expiring on 31st December 2023. Following consultations with the African Group, the Bureau recommends to the Assembly to dispense with the nomination period for the filling of a vacancy on the committee as required by Resolution ICC ASP/4/Resolution 6, and to elect the candidate nominated by Kenya and endorsed by the African Group, Ms. Sanyu Avori, to fill the vacancy for the remainder of the term of Ms. Shava until 31st December 2023. The Bureau further emphasized that the decision to dispense with the nomination period will not set a precedent for future elections by the Assembly, and agreed to recommend that the Assembly proceed in this manner on the basis that the decision to dispense with the nomination period is taken at the request of a regional group that has agreed to proceed in this manner and has made this request to the Assembly. Does the Assembly agree to proceed accordingly? I see no objection. It's so decided. Ms. Sanyu Avori of Kenya is therefore elected to fill the vacancy on the Committee on Budget and Finance for the remainder of the term of the member who resigned, that is until 31st December 2023. In accordance with Resolution ICC ASP/4/Resolution 6, she will be eligible for re-election. I congratulate Ms. Avori on her election. We have thus concluded our consideration on the casual vacancy of the Committee on Budget and Finance. Distinguished delegates, the Assembly will now revert to Agenda Item 4, States in Arrears. The Bureau of the Assembly received a request from Guinea for an exception from the loss of voting rights for the 21st session of the Assembly. I remind you that the Bureau decided to recommend that the Assembly grant requests for waivers at the 21st session on an exceptional basis, while also emphasizing the need for the state's parties concerned to engage with the Registrar of the Court on an urgent basis in order to establish a plan for payment of arrears. The Bureau also decided to revisit the issue next year in order to determine the way forward. On this understanding, may I then take it that the Assembly agrees to exempt the Guinea from the loss of voting rights? I see no objection. It's so decided. Distinguished delegates, we have heard the introduction of some of the draft resolutions for the 21st session, but we'll need to return to the budget resolution. Based on the update provided today, if there is good progress in the informal consultations today, I understand it may be possible for us to convene a plenary meeting this afternoon in order to hear the introduction of the draft resolution on the budget and to adopt all of the resolutions and conclude our remaining agenda items. If it seems that this will be possible, a communication will be sent to you by the Secretariat. I encourage delegations to make every effort to resolve the outstanding issues in their discussions today. We have thus concluded our business for the 8th plenary session. I have an announcement for the African group that they will meet at 11:30 in the Oceania foyer. Unless I see any requests for the floor at this very moment, this meeting, I don't see any, so this meeting is adjourned, and I wish you all a pleasant day with the budget considerations. Thank you very much.